I'm going to give you a high level, easy to understand overview of operating agreements. So listen up. I think this is going to help you a lot. And I go over this information a lot with clients. This is the same discussion I have with them when they're asking me about operating agreements. So I like to think about it as a three-legged stool. So the three parts, main sections, and there are other little pieces other than this, but think about it as three main things. Operation and control is one leg. Transfer, transfer restrictions is the second leg. And the third leg is restrictive covenants. So break that down a little bit. Operation and control is going to be, is this member managed? Is this manager managed? Is it one person, one vote? Is it we vote by percentage interest? Are there different classes of membership interest? You can have a real deep dive, and all this stuff's fully customizable because that's the beauty of the LLC. The operating agreement's the contract between the members, and it's all contractual. They can really customize how they want to manage this company. So think about those things. Who's going to do what? Who's going to control what? How are things going to be decided? Typically, I like to think about member managed as more like a traditional partnership where the members are kind of making every decision. They check in with each other and they make the decisions. Okay, you can hire officers and things like that, but that's generally how it is. The manager managed, I like to think about that as the manager, which doesn't have to be a member, by the way. It could be a third party, but oftentimes it is another member. That person is tasked with the day-to-day operations of the company, and they don't need to get the members' approval. It's kind of like having a CEO of a company. And the members in this case would be like the board of directors. They're just going to make the major decisions of the company. So that's generally that first leg, operation and control. Transfer restrictions is really important too, because this is typically a closely held company, and typically the partners, really members, they've contracted to go into business with each other, not the children of the partner, not the spouse of the partner, not the creditor of the partner, or some third party that the partner might decide to sell their membership interest to. So in those cases, it's not uncommon to have all transfers be void unless there's some kind of unanimous consent, meaning you're stuck in this thing. You can't just go sell your membership interest. But what happens if the person dies? Do they want their kids to benefit from the income, the growth of the company? Do they want their spouse to benefit from the income or the growth of the company? These are a lot of nuanced issues that these standard form template operating agreements just don't cover. You really need to ask those questions and get down to the nitty gritty and draft around it. So it's pretty common. One device that I'll use is one in which if there is a permissible transfer, you'll define what that is, and it might be passing on the membership interest to a member's heirs. Then one of the other members can essentially force a buyout. Okay? So we're going to protect that member. They can force the buyout, but we also want to protect the children, right? Because that's what's fair is fair. And so we come up with some formula in which we're going to value those interests and a way for those interests to be paid for. So there are different ways to do that. It doesn't have to be all at once. It could be by promissory note over a period of time with some interest. So these are all things that can be custom drafted and brought into this contract. So that's generally this second leg of the stool. Third leg of the stool is restrictive covenants. So what is a restrictive covenant? That's your confidentiality agreement. That's your non-compete agreement. That's your non-solicitation as to customers, and it's your non-solicitation as to employees. So what do these things typically do? Okay, so these things, in my opinion, keep the partnership together. Okay, it's a wonderful honeymoon. when the members get together and say, we're going to form the company and we just need a simple operating agreement. We've known each other forever. We've been friends. I respect them, their family, whatever it is, it's fine. Think about how many marriages fail. Okay. Now ask yourself, how many partnerships do you think fail? And a pretty robust part of our practice here at Johnson Law is partnership divorces. So the costs of a partnership divorce or the consequences can be mitigated through carefully thought out, custom drafted provisions and an operating agreement. So there are those restrictive covenants. Again, that keeps the partnership together. You want to incentivize these people to work things out to make it happen, because if they have to break up, they're not going to be able to compete with each other unless there's like a buyout or a settlement or something like that. Now, what if the person, and this is kind of part of the restrictive covenants too. This is another big issue. I kind of mix it in there. What are the consequences of violating a restrictive covenant? What if they go out, the member, and just starts a competing business or starts funneling customers? Okay, well, you could sue them for breach of this contract, for breach of fiduciary duty, things like that. And then you're stuck in this lawsuit. You got to prove up all your damages. But guess what? It doesn't automatically terminate their status as a member. It doesn't terminate their membership interests unless put it in the operating agreement. So I think removal of a member for cause is something that should be considered in every operating agreement. What are the consequences for not only breach of the restrictive covenant, but for breach for theft of company property, for other things like that? And this, again, needs to be carefully worded, because you don't want this for cause provision to be invoked by the other side as a weapon, right? You want it only to be invoked if it truly should be invoked. So these are the things that we talk through with clients on how best they think they should do it, what our suggestion is, and how to do it. And we have that discussion along with this whole discussion on the three-legged stool before we start deep diving into a custom-made operating agreement, or what we call in Texas a company agreement. So the members can think about these issues beforehand. That's their homework, and to come back with us with well, this is what we're thinking on each of these main things. And that way, when we go into the agreement, we can make some substantial, customized, thoughtful changes, not just pulling some form and selling it to a client, but providing real value in preparing one of these operating agreements that'll serve our clients best.